Hi, I'm Greg Dell, joined by attorney Stephen Dell, and today we're going to talk about the application process for short and long-term disability benefits. And Stephen, I know you've handled tons and tons of disability applications, probably in the last 40 years. How many would you say you've done?
Thousands.
Okay. And that's probably the primary area that you focus on right now, is doing the applications as well as the denials?
Well, if you get the application right, Greg, the likelihood is that you're going to get an approval. It's when you make a mistake in the application process that the claim gets scrutinized somewhat more closely and the potential for a denial is greater.
Well, I want to walk through the process of how you help people with the application. And a lot of people who are watching this video found us either through YouTube or on the net because they have either heard stories about disability insurance companies, or they've just received this information and they're like, what do I do with all this information? How do I answer this question? How do I get an attending physician statement? Why are they asking for my financials? All the information that you know about. So from a starting point, if someone were to call our firm and say, hey, I want help with my application, what do you need to see to get the ball rolling?
Well, Greg, what I have noticed over the last number of years is that you're right. Most people have no idea. They know that they have a policy. Either they bought a policy on the open market through a private broker, which is called an individual disability income policy, or they have a policy which is given to them as a benefit of employment, which is a group policy generally governed by a law called ERISA. That's the Employees Retirement Income and Security Act of 1974. They have no idea what their policies say. A lot of them have reviewed the policy, found it so frustrating that they kind of throw their hands up and call us. And by the way, that's not just the person who works at a hospital or works for an airline or is a government employee. I get calls from lawyers who are not contract lawyers or insurance lawyers, so to speak, who really don't understand their policy. So where do I start? I ask for the policy. The policy is a roadmap.
All right, and this may seem, it is a very common question. For the people who didn't buy their policy from their agent, how does someone even get a copy of their policy? Because often we ask people for their policy and what they send us is not really the policy.
There's a number of ways they can get it. I generally say go to HR and ask for a copy of the policy. Often that doesn't work because HR doesn't have it, may refer the potential claimant to the actual carrier. Call the carrier and they'll send it to you. Or they'll say, we have an online portal, and go on the portal and you'll be able to find your policy, which generally is not the case. There's a summary, and there's a difference between a summary, which doesn't get into the specifics of the policy, the exclusions of the policy, the ultimate benefits of the policy, and then there's the actual policy. So the place to start, of course, is HR. And the potential claimant might get lucky there.
Well, as you know, under ERISA laws, the employer is required to provide a copy of the policy. So while if they do say they don't have it, there is a regulation where if you send a letter to the employer, they have 30 days to provide the policy. And if they don't, they get fined $110 a day, which is basically never really gone after. But a lot of people who contact us go, well, you know, I'm thinking about disability because I'm struggling at work, but I'm also scared to approach my HR because as soon as I ask for disability, they may want to fire me. And what issues does that raise? Should there be a concern that if they were to get fired at that point, then, you know, or can there be a retaliatory firing because they're just asking for the policy? So do you tell claimants some kind of advice in the manner in which they ask their employer when they say, why do you want the policy?
I do, and there is an issue that you've raised, and that is that these policies, if we're talking about the group policy, they generally provide coverage. Coverage means that you actually have the benefit, the opportunity to file a claim from the carrier. There's generally a provision which says that you will be covered as long as you are an employee. And the issue is if you ask for the policy, your employer has no idea that you're impaired and have restrictions and limitations, and you're discharged before you've had the opportunity to put your employer or the carrier on notice, it opens the door for the carrier to potentially deny coverage. So in asking for the policy from HR, you don't have to give a reason as to why you want it. More times than not, and it's rare that someone's going to be discharged just because they asked for the policy. And I advise clients, say, I would like to see my policy, my various employment benefits.
Right.
Ask for your health policy, ask for the life policy, ask for the home health policy. That way they're not zeroing in on, wow, this person is a potential disability claim, and we're going to expect a Family Medical Leave Act claim.
That's a great tip. Once you get the policy and you're working through this process now with a potential client who's talking to you, what are the important things that you need to know in order to move forward with a claim? Meaning, what do you really need to know from the claimant in order to set this plan of attack or strategy for them?
Well, first and foremost, what's going on? Why are you sick? What is your diagnosis, if you have one? What are your symptoms? Did you have an accident? Because often the policies could provide different benefits if it's an accident, injury, or a sickness, especially in those cases where it's a group policy. I first want to determine, after I understand that the person is in fact impaired, what are the problems you're having at work? What is your job? What do you do every day? Are you missing work? Have you missed work yet? Have you advised your employer? Have you seen a doctor? Often we get calls that people have symptoms. They've diagnosed their own symptoms on the internet, but of course they should start with perhaps a family practitioner. But the real important issues, once I get beyond the fact that they are impaired, they have an occupation, is do they meet the minimum requirements to be covered under the policy? Is there coverage? There's a difference between coverage under a policy and the benefit under the policy. Coverage means I have a policy that if I meet the definition of disability, that potentially I could get a benefit. So what are some of the coverage issues? In many of these group policies, there's a requirement that you work a minimum amount of hours. Most are 30 hours per week. I have seen a number of policies that are a minimum 20 hours per week. Where you perform the services. Years ago, the policies required that you perform the services at the location of employment of the employer.
Right.
We're not seeing that anymore because there's so many work from home. And since COVID, really most group providers have removed the work within the premises of the employer, and they include a home office of the employee as the premises. So once I determine that they work a full-time job, the next issue is whether or not it is an on-the-job injury, an off-the-job injury, because sometimes there are different definitions related to a workers' comp type of an injury. I then will ask them whether or not there has been a sickness or injury that would be excluded under the policy. For example, commission of a crime. And while it might sound odd, I have had claimants who have called who have actually committed crimes that excluded them under the policy, even though they met the definition of disability. Generally, military-related type injuries would be excluded. Suicide, attempted suicide, generally is excluded. Cosmetic surgery, which results in an impairment, cosmetic surgery that has gone wrong, may result in an exclusion under the policy. So I want to make sure they're covered. Another crucial issue is, when did you start work? What was the effective date of your policy? A pre-existing exclusion means that the policy is going to exclude a illness that impairs you if it's a recent illness that manifested itself shortly after the policy started or shortly before the policy started. Generally, a pre-existing exclusion means, and it's different from policy to policy, but what's very common is if you've treated with a doctor or your symptoms would have necessitated that a reasonable person would have sought medical care within the 90 or so days prior to the effective date of the policy, and you become impaired within 1 year after your commencement of work, and we'll say that the policy starts at commencement of work, but it doesn't always, that would be an excluded basis for coverage under the policy. So I take many calls and respond to many inquiries on the internet, which once I've done an investigation, it's unfortunate that I have someone on the line that's impaired, meets the definition of disability, but falls under an exclusion.
Right. And the pre-existing condition that you just mentioned is a very common exclusion, one of the first things that the disability insurance companies look at. Yesterday, a gentleman called me and he said, I have a genetic eye disorder I just found out about 5 years ago. And I've been working with this condition. I know about it, but it was before my, I've had it for years. So my first question to him was, well, how long have you been with this employer? And he said, I've been there for 5 years. I said, well, you have no problem because you've been there for at least a year and that's not going to be an issue. He said, well, one of my prior bosses is looking to take me into a new company. I said, well, if you go to the new company and you have this pre-existing condition, you're going to have to wait at least a year there without having any disabling issue in order to get coverage. So he was thankful for that advice, but the things that you just explained, all the exclusions are fundamental in saying, hey, look, before we even determine if you're going to if you're going to qualify for benefits, let's make sure you don't have exclusions. So that was a great summary you just gave of the exclusions. Now, when you move forward, and I'll pitch you a softball here, what are the most important things generally for a claimant to get their benefits approved? What are the most important pieces of evidence that they need to have in order to get this application approved for them?
Okay, so you have to actually have a strong foundation in order for a claim to be approved. And what are the elements of a strong foundation? Well, first of all, a real impairment. I don't feel good is not good enough. I am suffering burnout is not good enough. The individual needs to have medical or psychiatric care. And we're seeing as many psychiatric claims as we are seeing physiological claims. Have you gone to the doctor? Have you gone through the various treatments and modalities that your doctor has recommended? Many of these things, if not all of them, should be done before you notify your employer that I can't work anymore. So you've had the diagnostics, you've been to the doctor, you've taken the meds that your doctor wants you to take, and you're not doing well. It's impairing your ability to work, or you can't work anymore. You don't just leave. You have to have the talk with your physician. And the talk with your physician means that, doctor, let me explain to you what I do. A call I took this morning. I'm a BMW salesperson. I have to do everything, meaning that I have to make sure that the potential customer is welcomed. I have to show them the vehicle. I have to go over the cost. I have to go over the financing. And this particular BMW salesperson had been in a car accident and suffered a TBI, a traumatic brain injury, and is unable to multitask. He could not do all of these things. I advised him, have you discussed with your neurologist who would take care of a TBI what you're going through at work? Yes. Does your neurologist know what you do for a living? Just the fact that you're a car salesman, does he understand that you have a list of 30 things you have to do?
But why? Why does the doctor need to know that?
Because the doctor has to render an opinion that this patient of mine, with my understanding of what you do for a living, is not able to do generally the substantial material duties of, and in this example, of a BMW salesperson. If the doctor is listening to you and the doctor understands what you do for a living and is, of course, aware of your physiological or psychological condition, willing to say and complete a form, which is called an attending physician statement, that Mr. Jones at this time is not able to perform the duties of his occupation. And that is one of the greatest hurdles in any disability claim, whether it's on the group side or the individual side.
So the most important element of any application for benefits is the medical support.
It's the most important and the most problematic. And the reason why I say problematic, Greg, is because a lot of doctors are quote-unquote doctors. I treat sick people. I treat injured people. I don't fill out insurance forms. It's not part of my job. And in the case of someone who needs to file a disability claim, that's almost unacceptable because we as counsel will be limited in presentation of the claim and in the claims package brochure that we prepare for the insurance company if it's missing the doctor's form, which is the attending physician statement.
In representing a claimant, what is your role in assisting with the completion of the attending physician statement? And to take it a step further, what role, if any, do you have in guiding a client to make sure their medical records are strong enough to get benefits approved? Because you know how the disability company is going to look at it.
Early on, I will ask the clients not only for a copy of the policy, but get me the medical records that you can. Get me the ER report, get me also the accident report if it happened to be from an auto accident. Let me see the diagnostics. Have you had a CAT scan, x-rays, MRI? I read those things daily. I read the diagnostics in conjunction with the medical report. Most every doctor on the psychological or on the physiological side will prepare office notes. And they're going to say, the patient has the following history, the patient has the following symptoms, and often there'll be a summary or a conclusion at the end of the report. If that identifies restrictions and limitations or symptoms that this patient is experiencing, fitting the pegs into the hole as it relates to presenting a convincing claim to an insurance company is pretty much established. The missing link is the attending physician statement. And I counsel our clients how to present that to the doctor, how you create an empathetic provider. And more times than not, we're successful, almost always successful in that regard, in getting a doctor to complete a form. And if the patient is unsuccessful, I'll go so far as to advise the patient, ask your doctor if he or she is willing to have a 3-minute conversation with me. Because often when they realize that I'm not asking the doctor to say this person is disabled for the rest of their life, this person is not disabled from any occupation at this time, but from the occupation that they perform, the doctors tend to come around and generally want to help the patient as long as it's not a tremendous inconvenience to them. And I try to expedite the whole process.
All right. So we talked a little bit about the medical and the role that you play in the medical with the claimant, and there's a lot more to that, to what goes on with the medical and getting the right medical and going to the right doctors. And I know that you guide the claimant because what they may be going to for treatment of one condition may not be strong enough where you may recommend an additional medical test, or why don't you have a consultation with another medical expert, because we always want to strengthen the file to make it as strong as possible, always thinking from the frame of mind is how is the disability company going to look at it? What are they going to try to poke holes in to deny this claim? So we're always trying to build a huge battery of strong medical evidence. But in addition to the medical evidence that you build for the claimant, what's your role in terms of communication with the disability company? Are you behind the scenes? Are you up front? Does the claimant have to talk to the company? What do you recommend, and how do you usually operate?
Well, it's generally a relief to the claimant, our client, that they almost have no contact with the insurance company at all. And that's good for them, and they're relieved because they're stressed.
Mm-hmm.
They're potentially going to lose their income. They have a family in most instances, and they are afraid of saying the wrong thing, or saying too much, or saying too little, and really have no idea how the process works. So our firm becomes the front men and women on behalf of the claimants. It's not adversarial. It's actually cooperative. It's really important to have a good relationship with the insurance companies. You deal with them every day. There are only a very limited number of insurance companies left. There's been so much consolidation in the industry, especially, well, both on the group and on the individual side, that we're dealing with the same claims adjusters, the same supervisors on a regular basis. And it's important that what we present to them is credible, complete, nothing is hidden, but presented in a light most favorable to the claimant, to the insured. And yeah, I scrutinize everything. In the event that someone's complaining of lower lumbar and the treating physician has taken an x-ray and said you probably have a herniated disc, I will advise the client that's really not good enough. I would like you to go for an MRI, because an MRI is going to identify it, and the insurance company has in-house physicians as well as third-party physicians who are going to review the medical records, and they're going to make a determination, does it make sense that this individual with these complaints would not be able to perform the duties of their occupation? So in answer to your question, the more evidence we have to support what the claimant is saying and his or her inability to perform his or her occupational duties, the stronger the claim is, and the more likely that we're going to get a claim approval upon submission.
When you do the application, though, the disability company cannot contact the client at all. All communications comes to your office, correct? There's never going to be a random letter sent to the company. They're never going to be asked to do anything on their own, all because everything's going through you. So if they hear no news, it's potentially good news, and they're never going to get caught off guard or have to randomly tell the disability company something without your guidance. Is that how you operate?
Yes, and never say never, Greg, because every once in a while, a claims adjuster who hasn't reviewed the file will pick up the phone and call the claimant. And we advise the claimant just to say that I have counsel who is assisting me on my claim. And I tell them, don't even use the word representing, because this is not a litigation situation. This is not an adversarial situation. Certainly the carrier is not your friend, but say, I'm being assisted by. Would you please call Stephen Dell, Greg Dell, or any other of the lawyers? And the carriers do. And then I respond rather quickly, and then inform the client of exactly what, where, and why.
We have many other videos about the details of everything surrounding an application process, but the last question I want to ask you is, once you get your claimant approved, do you continue to represent them? And if so, why do they still need you at that point?
The claim approval is the first hurdle. And generally clients are delighted. Of course they are, because they're going to get their benefit as soon as the elimination period has been established. And the carriers are scrutinizing the claims. They're continually scrutinizing the claims. The internal requirements for the claims administrators are that when a claimant gets on claim and they're receiving their benefits, do they continue to meet the definition of disability? And the definition of disability early on in a claim, in a group plan, generally for 2 years, would be the claimant's occupation. In the example I gave you, the BMW
Right.
salesperson. In many of these policies, in fact, in most of these policies, after a 24-month period, the definition of disability changes. And then it goes to the inability to perform not your specific, but any occupation. So my job is always working, monitoring medical records, monitoring what the limitations and restrictions of the claimant are, and continued communication between the client and myself so that I know what they're doing, where they're, the direction that they're taking, that they're going to their doctor, that they have to go to their doctor prepared in a truthful way to tell the doctor what they're experiencing, what their problems are, and that we need to be proactive, not reactive. A carrier likes to see that the claimant has gone to their physicians, has had the appropriate diagnostics, has followed their physician's advice, and implied in all of these policies is something called appropriate care, meaning that if your physician tells you to go for physical therapy, unless there's a reason why you can't, go for physical therapy, because you can be sure if you don't, if it says in the orthopedic surgeon's office note that I have advised the patient to go for PT, physical therapy, and the claimant has decided, I'm not going to do that, the carrier is going to question it, and it could place continued benefits in jeopardy for not following the appropriate care requirement.
Well, there's obviously, a lot of people think when they apply for benefits, it's like when they applied to get the policy. Either they just paid a premium or they filled out one application and the company said you're approved and start sending us checks every month or annually or whatever it is. But and what we want people to understand is that it's a whole nother world when you get into filing a claim. That it opens up an entire can of worms and you're constantly under the microscope of having to prove your disability on not necessarily a daily basis, but every month. Every month there's a human being who's called a claims analyst at the disability insurance company who has to check off boxes as to, is this person still eligible? Do they still meet all of the definitions of disability? Do they have the medical support? And that's the reason why we continue to offer a monthly claim handling service where every month we're protecting the benefits of the claimant moving forward, because some people think once you get approved, it's going to go on for as long as you need it. And unfortunately, that's not the case, which is why we get calls every day of people who've been denied after initially 1 year, 2 year, 10 years, 15 years, 5 years, any random time. And the reasons for denial are a multitude, which we have, again, lots of videos talking about that. But the goal of what I know you do is to prevent that denial from happening, get you approved, and prevent the denial from happening in the future.
Greg, the claimant and the lawyer needs to be vigilant. You cannot put your guard down. You put your guard down, then there's going to be a problem. You don't go to the doctor for regular visits, there's going to be a problem. And you have to understand the carrier's point of view. They need to know, are you still impaired? Do you still meet the definitions under the policy? And our job is to make sure that not only that you do, but that the carriers are well aware. Often before they ask, we let them know. Be proactive.
That's fantastic. Well, I know you always offer an initial free consultation where you will review a policy for a claimant. If there's someone who's considering applying or if they're already on claim, that you'll always ready to jump in and help them manage their claim. I always encourage people to go ahead and give us a call. No matter where they live in the country, we're available to assist them. And thank you for explaining the whole application process and what you do to help claimants.
With pleasure, Greg.